Hello everyone, I'm George from Ireland. So this is another talk about criminal law, and this is going to be about the coincidence of the actus reus and mens rea. Sorry, I should say actus reus and mens rea. You're not supposed to use articles in relation to these two terms, it's their Latin. Okay, so there's got to be temporal coincidence, as in time, got to be happening at the same time. Okay, so if one person is trying to steal someone else's wallet, the defendant is trying to steal the wallet, and then a few seconds after that, the defendant decides, well, I'm going to put the wallet back. Is he guilty of theft? Now, most people would say, yes, he is. But others would say, well, no, he was committing the actus reus, but the mens rea wasn't there at the same time. Anyway, so there was a case called Ahmed in 1986 about this. So a landlord was accused of harassing his tenants to try and get them out of the building so he could rent the place to someone who's going to pay more. But then he was found not guilty of this crime because it was determined that he only formed the intention of getting them out after he'd started harassing them. Okay, might seem like the law is an ass, but there we are. So there are ways around the need to have this temporal coincidence. So take the case of Miller, 1983. There was a fire that was started, but there was no mens rea here because the defendant was asleep at the time the fire started. So the mens rea was only formed after the act had been carried out. When Miller woke up, realized his bed was on fire, but didn't do anything to put it out or alert others. Anyway, he was not found guilty of criminal damage. So the actus reus could be based on the fact that he omitted to extinguish the fire. Now that omission, an omission can be much of an action as a commission, was accompanied by the mens rea, and that was of recklessness. So the actus reus and mens rea came together at that same time when the defendant chose not to put out the fire. Anyway, because you have a duty to put out fires when you can. So sometimes we use the continuing act doctrine to circumvent the requirement for there to be temporal coincidence. Look at Fagan against the Metropolitan Police Commissioner, 1969. This is the guy who drives onto the policeman's foot accidentally. The policeman said, "You're on my foot, reverse." But no, I'm going to keep my tyre on your foot. So the trouble is, the actus reus, the driving onto the foot, and the mens rea were not at the very same time. But so people say, well, he can get away with it, therefore. But the actus reus and the mens rea didn't exactly coincide because the mens rea, the guilty mind, was only formed after the action which caused the harm had been carried out. So he'd parked on the guy's foot innocently. Anyway, the Queen's Bench Division said, no, this is a continuing act, and the failing to remove your car when called upon to do so, that is an act as well. That's the actus reus. Anyway, so he was found guilty. It went all the way. Obviously, he'd appealed, but the conviction was upheld. So, and there are these supposed corpse cases. So we see the principles here in Miller and Fagan. There are two qualifications, the actus reus and mens reus coincidence rule. So these aren't exceptions. They are ways of getting around a more stringent application of the rule. Look at the supposed corpses cases where you assume someone is dead. The person's actually not dead at that time. So the defendant believes he's killed someone, but the victim isn't actually dead at that time. Attempting to dispose of what he believes to be a corpse ends up killing the victim. So there's Malice against the Queen, 1954. In this case, people actually plot to kill the victim. The idea was to get the victim to come to a secluded place, to bludgeon him to death, and then roll his body off an escarpment. And then when his body was found, the injuries would appear to be consistent with falling off the cliff. Now the plan, the early stages of the plan went according to the plan. So the victim was persuaded to go to that remote and isolated location. He was given a good hiding, and then the defendant assumed that the chap was dead, so then they pushed him off the cliff. However, he actually wasn't dead. He hit the ground, and then he died some time later of exposure. So the defendants were charged with murder, but they said that the cause of death, which was their attempt to dispose of what they thought was a cadaver, was not accompanied by mens rea at that time because they assumed he was already dead. So the mens rea and the actus reus didn't come at the same moment. Now, the Privy Council said this is tosh. This is what the Privy Council said in denying the appeal. It appears to their lordships impossible to divide up what was really one transaction in this way. There is no doubt that the accused set out to do all these acts in order to achieve their plan, and as parts of their plan. And it is much too refined a ground of judgment to say that because they were under misapprehension at one stage and thought their guilty purpose had already been achieved before it was in fact achieved, therefore they're to escape the penalties of the law. That's Lord Reed. End of the quotation. So Church, 1966, is another case about this. Here they didn't come up with a plan. There was an argument about the chain of causation. The defendant panicked when he hit the victim. The victim, she fell to the floor, and the defendant thought he'd killed her. So, believing that this was a dead body, the defendant then threw the woman into a river, where the victim expired from drowning. So the defendant was charged with and found guilty of manslaughter, but then the defendant said that actus reus and mens rea didn't come at the same time. The Queen's Bench division said that this argument had no merit. They said that this homicide had occurred, he was guilty of that, because of the appellant's behaviour. And this is what the court said. Behaviour from the moment he first struck her to the moment he threw her into the river is a series of acts designed to cause death or grievous bodily harm. So they regarded the accused behaviour. It mattered not whether he believed her to be dead or alive when he threw her into the river. Close quotation. The judge there was Edmund Davies. Edmund is part of the surname, by the way. So the defendant here had the mens rea for manslaughter. When he hit the woman, the victim died, and it didn't matter whether she died from being the hit or being thrown into the river. The fact is, she died as a result of things he did. There's a chain of causation. There was continuity there. So Lebron, 1992, is another case about this, where causation is examined in some depth. The defendant hit his spouse as part of a heated argument in the street just outside the house. So the woman fell to the ground, hit her head, and lost consciousness. She died due to her injuries when the defendant, he dragged her from the house, from the road into the house, because he didn't want people to see her. So the actus reus and the mens rea, sorry, didn't come at the same time. I keep saying the, but you're not supposed to say the. So the Chief Justice was Lord Lane at the time, and in the Court of Appeal, this is what Lord Lane had to say. It would be possible to express the problem as one of causation. The original blow to the chin was the causa sine qua non of later actus reus. It was the opening event in a series which is to culminate in death, the first link in the chain of causation. To use another metaphor, it cannot be said that the actions of the appellant in dragging the victim with the intention of evading liability broke the chain which linked the initial blow to the death. In short, circumstances such as the present, which is the only concern of the court, the act which causes death, the necessary mental state to constitute manslaughter, need not coincide in point of time. Close quotation. So temporal coincidence, we're quite loose with that. There doesn't have to be temporal coincidence in some cases, because often it's an ongoing act, from the hitting her to the dragging her into the house. Okay, so there is a principle which connects to this. The mental element, remember mens rea, and the actus reus, that's the behaviour, the circumstance and consequence. The principle comes from this wider ethical principle about finding people guilty and punishing people if they deserve it. A person can be punished for doing something without the mental element corresponding to that something when the punishment is undeserved and unfair. All right. So anyway, for example, having intercourse with someone who lacks mental capacity, a minor, someone, a vulnerable adult or whatever, someone who is unconscious, this is a crime as well. Okay, there's an ethical and normative principle here, because there's the mens rea to commit intercourse with someone who's unconsenting. All right. So what else would I want to point out about this? Yes, there's transferred malice, and there's a correspondence principle here and a qualification there too. So if the defendant commits an actus reus of a crime, and the relevant mens rea for that crime, but the subject matter of actus reus was not what he intended or foresaw, that's there's no breach of the correspondence principle. Okay, so if a man tries to shoot Barney, but the man accidentally misses Barney and kills Charlie, is he guilty of murder? I wasn't trying to kill Charlie. Yes, he is guilty of murder. This is transferred malice. Mens rea for murder was there. Actus reus for murder was there. The fact that he killed the wrong person is neither here nor there. He still killed someone through committing this illegal act purposefully. So there was R against Ganango 2011, when it was a case matching that set of facts. So mens rea in relation to another person is still mens rea, and actus reus likewise. This is transferred malice. In this example I gave, his malice towards Barney, but actually it was transferred to Charlie, accidentally killing Charlie. Nevertheless, the defendant is guilty. So this is what Lord Mustall had to say in AG's reference number 3 of 1994. The effect of transferred malice is that the intended victim and the actual victim are treated as if they were one. So what has happened to the first person but did not happen is added to what actually did happen to the second person but was not intended to happen, with the result that what was intended and what happened are married to make a notionally intended and actually consummated crime. The cases are treated as if the actual victim had been the intended victim from the start. Close quotation. So the principle is applicable to all violent crimes, not only murder. Latimer, 1886, is a case about this. The defendant swung his belt in an alehouse. He missed his intended victim and hit somebody else. So the defendant was found guilty of the crime, even though he didn't intend to hit the person whom he actually hit, right? So this is true even if the harm suffered by the desired victim is different from the harm which the attacker wished to inflict. There's R in Grant, 2014. The defendant fired shots into a shop intending to kill somebody. The shots missed the person, and they hit some bystanders who didn't die, who were just injured. And the defendant was charged with attempted murder and causing grievous bodily harm. Okay, that's against Section 18 of the Offences Against the Person Act. So this was transferred malice. Anyway, so he was found guilty. He said, "But I wanted to kill this person and not to cause grievous bodily harm. So malice wasn't being transferred." The court said this argument is bunkum. Anyway, he was found guilty of everything. So bear in mind a qualification. The principle is only applicable to crimes which are similar to each other: grievous bodily harm, murder, and so on. In Pembleton, 1874, the defendant threw a stone at someone when he was having a fight with him, but it missed the intended victim and it hit a window. So he's charged with criminal damage. Now, the court for Crown cases is reserved so that he intended to hit someone, and that was meant to injure a person, and that didn't prove that he was guilty of criminal damage. So Lord Blackburn said the defendant could be guilty of criminal damage only if he wished to damage property or foresaw a considerable risk of damaging property. So his conviction was overturned on appeal. Perhaps that's strange and wrong, but there we go. He was trying to commit a more serious crime. He accidentally committed a less serious crime. I mean, everybody would know that throwing stones on a street could lead to damage to property. Even if it does hit your victim, could bounce off and damage property. All right, that's enough from me. Toodaloo.